Good afternoon. It's a pleasure to be here with you this afternoon to talk about some subjects, topics concerning U.S. litigation, particularly with respect to international and transnational aspects of U.S. litigation. Perhaps if I could just begin briefly by introducing our firm and where we have offices and what we do. We are a law firm of approximately 490 attorneys. Our firm only does litigation work. We have offices in Los Angeles, where our firm started and where I live when I'm not on an airplane. In San Francisco, Silicon Valley, Chicago, New York, London, Mannheim, Germany, where Dr. Marcus Grosch, who will be speaking to you, has his offices, and of course, here in Tokyo. These are the topics I want to discuss with you up on the screen here, just to kind of give you an overview of where I'm going in my presentation. First, I'm going to talk about the subject of personal jurisdiction in the U.S. courts over foreign litigants. By that I mean, under what circumstances, from the standpoint of U.S. courts and U.S. law, will a U.S. court exercise authority and power over a foreign person or entity? Second, I'm going to talk about the discovery of documents that are in the possession of foreign parties and their affiliated companies. The U.S. discovery system is very well known, perhaps notorious around the world, for being very extensive and burdensome. And I want to talk a little bit about under what circumstances a U.S. court will require a foreign party, which is involved in a lawsuit in the U.S., to bring documents and information, including electronic data, to be produced in the U.S. Third, I'm going to talk about a provision of U.S. law which I've found is really not very well known outside the U.S., which makes it under which a U.S. court has the power to require a party to make discovery, to produce documents, to produce witnesses for deposition, to assist a foreign court or a party involved in a foreign litigation outside the U.S. It's a very interesting procedural device which I don't think many people know about and should be, I think, used or considered more frequently than it is. And then fourth, I'm going to talk just generally about some of the things that we've learned in our experience from the problems associated with coordinating litigation where you have related cases that are pending in multiple jurisdictions. So first, the question about personal jurisdiction in the United States over foreign parties. And by personal jurisdiction, I mean, under what circumstance under U.S. law will a U.S. court determine that it has the authority over a foreign party which has been sued as a defendant? If the U.S. court does not determine that it has personal jurisdiction, it then has no authority to proceed with the case and obviously has no authority to grant any relief, whether damages or an injunction. In general, And I will talk about each of these separately, but there are three general categories or bases over personal jurisdiction over a defendant under U.S. law. The first are the traditional bases of personal jurisdiction, that is that the defendant is actually present in the forum. And when I use forum, by the way, I'm talking about the particular state, whether it's California, New York, Florida, the particular state where the case is pending. The court in that state must have jurisdiction. With very few exceptions, there isn't personal jurisdiction based upon nationwide presence in the U.S. It must be determined on the basis of the defendant's presence or not, or its contacts or lack of contacts with the particular state in which the court sits, whether it's a state court or a United States federal court. Second, so-called specific jurisdiction, which means a case, whether a court has jurisdiction, but it's limited, it's specific only to issues and disputes arising out of the defendant's contact and activities in that state, in that particular forum. And third is general jurisdiction, that is to say that the defendant is present in the forum or has its activities in the forum are so extensive that the court will determine that it has authority, general authority over the defendant to resolve any dispute, any claim brought against that defendant, whether it relates to the activities in the forum or not. So those are the three bases for jurisdiction, and I'm now going to talk about each of these. First, the traditional basis for personal jurisdiction, of course, is first that you're actually able to effect service of process of the summons and complaint on the defendant in the forum. Typically in the case of corporate entities, they're talking about serving an agent who's actually physically present in the forum. Under the laws, I think, of all 50 U.S. states, foreign companies, and by foreign in this sense, I mean not just foreign non-U.S., but also, for example, a Delaware corporation that's doing business in California, from a standpoint of a California court, would be regarded as a foreign entity. Foreign entities doing business in U.S. jurisdictions are required to make a filing with the Secretary of State of that state, under which they agree that the Secretary of State can accept service of process of a summons and complaint on behalf of the defendant. So that's first basis for traditional personal jurisdiction. Second, domicile in the forum. If a person is actually resident and resident in the forum, the court will have jurisdiction. Or third, consent. Obviously, a party can consent to personal jurisdiction. And this can happen by accident. If a party, a foreign entity, is sued and service is made, and the defendant appears, answers the complaint, and does not reserve its objection to personal jurisdiction, it's deemed to have consented to jurisdiction in that forum. That can sometimes happen by mistake, but that is deemed consent if an objection to personal jurisdiction must be asserted, if at all, right at the first opportunity at the outset of the lawsuit. Frequently in contracts, there will be a consent provision where the parties agree that any dispute, for example, arising out of the contract will be decided in a particular identified forum in the U.S. The state, the courts of New York, for example, or the courts of Florida. That is consent. A choice of law provision, the selection of a choice of law saying, for example, that this contract will be governed by New York law, will not in itself be a consent to jurisdiction in New York. So choice of law provisions are different than consent to jurisdiction, or sometimes called forum selection clauses. So those are the traditional bases for personal jurisdiction. Now specific jurisdiction. Again, specific jurisdiction relates to the court's jurisdiction over a defendant, but only with respect to claims arising out of that defendant's activities in the forum or relating to the forum. And under U.S. law, this is a federal constitutional issue, so-called due process issue. It's regarded as unconstitutional to exercise authority over a defendant if they do not have sufficient contacts with the forum. And the way this is often expressed by the court is that the defendant must have purposely availed itself of the privilege of doing business in the forum. The cause of action, the claim, relates to the defendant's activities in the forum. And finally, kind of a catch-all general test that in the end the court concludes that it's fair and reasonable to require the defendant to defend a case in the forum. The concept, let's talk a little bit about the concept of the purposeful availment of the privilege of doing business in the forum and what that means. And what that means is the courts say that the decisions indicate that the defendant must have directed its activities, its business activities, to that forum sufficiently that it's fair to find that the defendant by its activities is potentially looking for the protection of the laws of that state. So it's fair to require them to actually appear and defend if claims are made. The U.S. Supreme Court in the worldwide Volkswagen case ruled that just because it's foreseeable that injury might be caused by putting products into the stream of commerce, that in and of itself, the fact that Volkswagen AG in Germany ships Volkswagen automobiles to the United States, and it's foreseeable that there will be a certain number of Volkswagen accidents in all 50 states. The court said that is not sufficient to give jurisdiction over the German parent company, even with respect to products liability claims, for example. The foreseeability that is critical is that the defendant's conduct in connection with the forum state are such that he should reasonably anticipate being hailed into court there. Now, what does that mean? The determination of jurisdiction in these cases is all very factual intensive. As I discuss this, I think that'll become apparent. There are not sort of bright line legal rules. It's very much a factual analysis as to what are the scope of the defendant's activities or contacts with the forum. So these tend to be very factual intensive issues.